The final coat of Chantilly lace white paint glided from the brush onto the top rail of the fence. A satisfyingly smooth, almost buttery motion. Arthur Henderson stood back, admiring his work. 3 weekends of meticulous measuring, digging, setting posts, and nailing pickets had culminated in this: a simple, elegant, 3.5-foot fence enclosing his modest backyard. Through the newly installed gate, he could see his 5-year-old daughter, Lily, chasing a butterfly across the lawn, her laughter a bright, weightless sound in the warm June air. The fence wasn't for aesthetics. It was for her. It was a perimeter of safety, a wooden embrace that turned their patch of grass into a sanctuary. He and his wife, Sarah, had stretched every dollar to afford this house in Oak Creek Preserve, a community known for its manicured lawns, pristine common areas, and, as he was about to discover, its rigorously enforced covenants. "Beautiful work, Arthur." The voice, deceptively pleasant and edged with steel, came from his property line. Carol Albright stood there, clipboard in hand, her posture as rigid as one of the fence posts, as chairperson of the Architectural Control Committee, or ACC. Carol was a familiar, if somewhat intimidating, presence in the neighborhood. She wore her authority like a well-tailored blazer, which, even on this sunny Saturday, she had paired with sensible slacks and polished loafers. "Thank you, Carol," Arthur replied, setting his paintbrush across the top of the can. "Just finishing up." "I can see that," she said, her eyes scanning the fence line not with admiration, but with the cold, diagnostic gaze of a building inspector. "There's just one small issue, a matter of procedure. You understand?" Arthur's smile tightened. In HOA terminology, procedure was rarely small. "I submitted the plans to the ACC 2 months ago. I have the signed approval letter right inside." "Oh, the design is perfectly compliant with Regulation 7.3, she assured him, a thin smile playing on her lips. "The materials, the height, the color all textbook. The issue isn't the fence itself, it's the location." She tapped a perfectly manicured finger on her clipboard. "You see? Your property backs onto what is designated as a common area view corridor. According to our records, your fence encroaches upon that easement by approximately 6 feet. Arthur felt a knot of confusion tighten in his stomach. He was an architect by trade. He lived and breathed property lines, setbacks, and easements. "That can't be right," he said politely. "I have the survey from our closing. I measured everything twice before I dug the first post hole. The fence is entirely within my property line." He walked to the gate, unlatched it, and stepped onto his lawn, gesturing toward the small metal stake, nearly hidden in the grass. That marked the rear corner of his lot. "The surveyor's pin is right there. The fence is a good foot inside of it." Carol did not glance at the pin. Her focus remained on the documents attached to her clipboard, the association's official plat map, the one that governs all land use within Oak Creek, indicates an easement extending 10 feet from the designated common area boundary. Your fence is only 4 feet from that line. That means you've built 6 feet into association property. She finally looked up, her expression a careful blend of sympathy and unwavering resolve. "I'm afraid it will have to come down. The committee requires the non-compliant structure to be removed within 48 hours to avoid a formal violation." Arthur felt a surge of disbelief, followed by a hot flash of indignation. 48 hours. He had spent over $1,000 on materials and 60 hours of his own labor on this project. "Carol, with all due respect, the association's map must be incorrect. This is my property. I have a legally binding deed and a certified survey to prove it." He walked back into his garage, retrieved the rolled-up survey from the tube where he kept his important documents, and unrolled it on the hood of his car. He pointed to the clear, professionally drafted lines. "See Lot 124. My property extends to this line. There's no mention of a 10-foot view corridor easement here." Carol gave the document a cursory, dismissive glance. "We appreciate your perspective, Arthur, but the committee's decisions are based on the governing documents of the association. Our records may differ from yours. You'll be hearing from us." She smiled that thin, unreadable smile again, turned with a crisp pivot, and walked away, her clipboard held like a scepter. Arthur watched her go, the scent of fresh paint suddenly seeming acrid and sour. This was no longer a simple fence. It was a battle line, and he was standing on the wrong side of it. That evening, the scent of grilled chicken and the sound of Lily's bath time filled the small house, a comforting domestic scene at odds with the anxiety coiling in Arthur's chest. Sarah listened intently as he recounted the encounter with Carol, her brow furrowed with worry. "She just expects you to tear it down. After all that work?" Sarah asked, her voice laced with the exhaustion of a young mother who saw a problem not as a principal, but as another drain on their already strained time and budget. Maybe we could just move that back section. Would that be so hard?" "It's not about how hard it is, Sarah. It's the principle," Arthur insisted, pulling out his thick 3-ring binder labeled Oak Creek Preserve HOA, governing documents. He had read the entire volume, the covenants, conditions and restrictions, CC&Rs, the bylaws, the rules and regulations before they even closed on the house. He was a man who believed in rules, in the logical and predictable frameworks that governed everything from building codes to community living. "We own this land. We paid for it. The title insurance guarantees it. She can't just claim 6 feet of our backyard because her map says so." He flipped through the tab sections of the binder, his finger tracing the dense paragraphs of legalese. His architectural training made him uniquely suited to this kind of textual warfare. He found the 2 clauses he remembered from his initial reading, a contradiction that had seemed like a minor semantic discrepancy at the time, but now loomed large. He highlighted the first CC&Rs, Rule 8.4.2, View corridors, it stated. "No structure, planting, or other material impediment shall be placed within any area designated on the association's official plat map as a view corridor easement, so as to preserve the aesthetic continuity and scenic vistas of the community." This was Carol's weapon. Then, he highlighted the second. Several chapters later, CC&Rs, Paragraph 12.1.5, Boundary Definitions. It read, "The boundaries of all private lots and common areas within the community shall be defined exclusively and finally by the official subdivision plat map filed and recorded with the Summit County Recorder of Deeds." This was his shield. "See," he said, showing Sarah the 2 highlighted sections. "The rules contradict themselves. One refers to the association's map, and the other, the legally superior clause, refers to the official county map. All I have to do is show them that my survey aligns with the county record, and this all goes away. It's a simple clerical error." Sarah looked from the binder to Arthur's determined face, then through the window at the new white fence, gleaming under the porch light. It was more than just a fence to her, too. It was the last piece of the dream, the final touch that made their house a home, a safe haven for their daughter. They had saved for years, making sacrifices, foregoing vacations, driving old cars, all for this house in this neighborhood, for the promise of community and security. The thought of that security being threatened by a petty dispute over 6 feet of grass made her anxious. "I just don't want any trouble, Arthur," she said quietly. "People like Carol, they thrive on trouble. Are you sure it's worth fighting?" "It's our home," he replied, closing the binder with a firm snap. If we let them take 6 feet of our yard today, what will they claim tomorrow? I'm not a troublemaker. I'm just a homeowner who read the rules. He felt a surge of confidence. He had the documents, the survey, and the conviction of being right. This would be a straightforward matter of presenting the facts. The email arrived on Monday, June 1st, at 9:17 a.m. It came not from Carol, but from a generic address, Compliance, Oak Creek Management, COM. The subject line was chillingly neutral. Courtesy notice, potential non-compliant structure at 124 Chestnut Lane. Arthur's heart hammered against his ribs as he opened it. The language was polite, almost robotic, stripped of all human emotion. It was far more intimidating than Carol's direct confrontation. Dear Mr. Henderson, this letter serves as a courtesy notice regarding a potential violation of the Oak Creek Preserve governing documents. It has come to the attention of the Architectural Control Committee ACC that a new fence structure located at the rear of your property, Lot 124, appears to be situated within a designated Common Area View Corridor easement, in contravention of CC&Rs, Paragraph 8.4.2. Please be advised that this is an informal notice intended to resolve the matter amicably. We kindly request that you remedy the encroachment within 14 days of the date of this notice. If the issue is not resolved by June 15th, a formal violation notice may be issued, which could result in further enforcement action, including the potential for monetary penalties. A copy of the relevant section of the association's plat map is attached for your reference. Sincerely, Oak Creek Management, on behalf of the Board of Directors. He clicked open the attachment. It was a scanned section of a map, showing his lot and the one behind it. A thick, dashed line cut across his backyard, labeled 10s VCE. His fence, represented by a neat, hand-drawn line, was clearly inside it. The threat was no longer just a neighborly disagreement. It was documented, dated, and officially sanctioned by the association. The clock was ticking. Convinced that a simple presentation of his own evidence would clear up the misunderstanding, Arthur composed a meticulously professional email to Oak Creek Management. He was courteous, factual, and non-confrontational. He cited CC&Rs, Paragraph 12.1.5 explained the discrepancy, and attached a high-resolution PDF of the certified plat map and survey he had received at closing. He concluded by respectfully requesting that they update their records to reflect the legally filed documents. He hit send and felt a sense of relief, confident that logic would prevail. The response, which came 2 days later, was a soul-crushing exercise in bureaucratic indifference. It was another form letter, almost identical to the first, stating that his correspondence had been received and logged, but that the committee's position remains unchanged. Frustrated, Arthur called the management company. He was put on hold for 10 minutes, listening to a tinny instrumental version of a pop song he vaguely recognized. Finally, a harried-sounding property manager named Dave picked up. Arthur explained the situation calmly, referencing his survey and the county records. Dave's reply was a verbal shrug. Look, Mr. Henderson, I understand what you're saying. I really do. But my hands are tied. We are the managing agent for the association. We operate based on the official documents provided to us by the board and its committees. The ACC, which is chaired by Ms. Albright, has provided us with the map we sent you. That is the document of record for us, unless the board directs us otherwise. That's the map we have to enforce. But it's the wrong map, Arthur insisted, his voice rising despite his efforts to remain calm. The legally binding map is the one on file with the county. You are welcome to present that information to the board, Dave said. his tone making it clear the conversation was over. In the meantime, the deadline of June 15th is still in effect. The click of the phone disconnecting felt like a door slamming shut in his face. The system wasn't designed to correct errors. It was designed to enforce its own version of reality, however flawed. On June 15th, the mail carrier's truck lingered at their mailbox longer than usual. Later, when Arthur went to retrieve the mail, he found a slim green postcard in the box. It was a certified mail receipt. His stomach sank. He signed for the letter at the post office the next day. The envelope was stark white, bearing the letterhead of the Oak Creek Preserve Homeowners Association. Inside was the formal violation notice. The language was sharper, colder. It cited the specific bylaw he had allegedly broken, referenced the courtesy notice he had failed to act upon, and gave him a final deadline. He had 10 days to either remove the fence or formally dispute the violation in writing. If he chose to dispute, a hearing would be scheduled. If he did neither, the association would proceed with all remedies available to it under the governing documents and state law, including the imposition of daily fines. The letter was signed by the entire board of directors. Carol Albright's signature, as ACC chair, was the most prominent. It was a declaration of war, written on official letterhead. A hearing, daily fines. Sarah's voice trembled as she read the letter over Arthur's shoulder. This is insane. They're treating us like criminals over a fence. The fear in her voice galvanized Arthur. His initial confidence had been eroded by the bureaucratic stonewalling, but now it was hardening into something else cold. Methodical resolve. He was an architect. He solved problems by gathering data and finding the truth in the details. He would do the same here. That night, he drafted his formal dispute, a carefully worded 2-page letter that laid out his case logically, citing the specific CC&Rs, and again attaching his survey. He sent it via certified mail, creating his own paper trail. The act of formally disputing the violation automatically triggered the next step in the due process chain, a hearing. With the immediate threat of fines paused pending the hearing, Arthur launched his investigation in earnest. He spent his lunch breaks on the Summit County Recorder of Deeds' clunky, outdated website, digging through a decade's worth of digitized records for the Oak Creek Preserve development. He found architectural plans, soil reports, and initial planning documents. On one of the earliest preliminary plat drawings from 2011, he found something odd. It was a faint, almost invisible annotation in pencil near his lot, a hand-drawn line with the note, "Discuss V.C.E. with M.A." He zoomed in, but the image was too blurry to make out clearly. M.A. Who was M.A.? His next step was to formally request records from the HOA itself, citing state statutes that grant homeowners the right to inspect association records. He submitted a written request for all board and ACC meeting minutes from 2010 to 2012, the period when the development was being finalized. A week later, a thick manila envelope arrived. He spread the documents across his dining room table. Most of it was mundane discussions of landscaping contracts, budget approvals, pool maintenance schedules. But when he got to the minutes for the board meeting of August 15, 2011, he found it. A section heading read, "Discussion of ACC Proposal for Easement Adjustments." But the 4 paragraphs that followed were completely blacked out, replaced by a stark white box with a single word, "redacted." A footnote at the bottom of the page read, "Section withheld pursuant to attorney-client privilege." A chill went down his spine. This was no clerical error. An error doesn't get redacted by a lawyer. This was deliberate. His investigation took him out of the house and into the neighborhood. While watering his hydrangeas one afternoon, he struck up a conversation with George Peterson, his neighbor from 2 doors down. George was an elderly widower who had lived in Oak Creek since the first houses were built. He was a kind, quiet man who spent most of his days tending his immaculate rose garden. Arthur, seeing an opportunity, casually mentioned his disagreement with the ACC over his fence. George's cheerful expression clouded over. He leaned on his shovel, his voice dropping to a near whisper. "Be careful with Carol Albright." "Son," he said, his eyes scanning the street as if to ensure she wasn't nearby. "That view corridor. It's personal for her. She's not just protecting the community. She's protecting her husband's original vision." Her husband, Arthur asked, confused. "Michael Albright," George said. "He was the developer. Built this whole neighborhood from the ground up. Passed away a few years ago. Carol sees it as her duty to uphold his legacy, no matter what." The initials from the planning document clicked into place. M.A. Michael Albright. Suddenly, the redacted minutes and the hand-drawn note took on a more sinister meaning. This wasn't just about a view. It was about a legacy. Knowing he needed an irrefutable, third-party expert, Arthur hired a licensed surveyor, a man named Evans with 30 years of experience mapping Summit County. He met Mr. Evans on a sweltering late June morning. For 2 hours, Evans and his assistant used a theodolite and GPS equipment, taking precise measurements and hammering in new, brightly flagged stakes. Finally, Evans rolled up his schematics and walked over to where Arthur was waiting anxiously. "Well, Mr. Henderson," he began, wiping sweat from his brow, "the good news is your fence is, without a doubt, 100% on your property. My measurements confirm your original survey to within a fraction of an inch." Arthur felt a wave of vindication wash over him. "I knew it. So the HOA's map is just wrong." "It's more than just wrong," Evans said. His professional curiosity piqued. He unrolled the copy of the HOA map Arthur had given him and laid it next to his own fresh survey on the hood of Arthur's car. "This map the HOA is using, it's a professionally drafted document. No question. But it's not the one on file with the county. I pulled the official recorded plat this morning to double-check." He pointed to a specific line on the official map. "According to the legal record, the common area boundary behind your lot is here." Then he pointed to the HOA's map. "On their map, they've shifted that line 10 feet into your property and the properties of your neighbors, creating this view corridor easement out of thin air. This easement you're in violation of. It doesn't legally exist." The words hung in the hot summer air. Arthur stared at the two maps. The truth laid bare in black and white. The HOA wasn't just mistaken. They were enforcing a fraudulent document. This wasn't a dispute about a fence anymore. It was about a deliberate, calculated deception that had been codified into the community's official records for a decade. The redacted minutes, the cryptic note from M.A., Carol's unyielding stance, it all snapped into focus. The fight had just become infinitely more dangerous. Armed with a certified survey and the explosive knowledge of the map discrepancy, Arthur felt a renewed sense of purpose. He wasn't just fighting for his fence. He was fighting for the truth. He had his wife, who was now a paralegal, draft a formal letter to the HOA's legal counsel, the firm of Blackwood, Finch and Associates. The letter was a masterpiece of polite, factual escalation. It laid out the evidence clearly, the new survey, the discrepancy with the county record, and a formal request to dismiss the violation and correct the association's map. He attached copies of everything and sent it off, expecting this definitive proof to end the matter. The response came a week later. On July 10th, it was not a dismissal. It was a declaration of total war. The letter from the HOA's lawyer was condescending and dismissive. It stated that the association categorically rejects the findings of your hired surveyor and stands by the official plat map in its possession, which has been the standard for all ACC enforcement for the past decade. The letter concluded with 2 paragraphs that made Arthur's blood run cold. The first formally scheduled his hearing before the board of directors at the upcoming annual community meeting on July 25th. The second was a direct threat. Please be advised that should the violation committee find in favor of the association, a daily fine of $100 will be levied against your property, retroactive to the date of the formal violation notice. Should these fines remain unpaid for a period of 60 days, the association will instruct our office to place a lien on your property and to pursue all available remedies, up to and including foreclosure. Sarah read the letter and broke down in tears. Foreclosure, Arthur. They can't be serious. They're going to try to take our house away over 6 feet of grass. The fear in her voice was palpable. They had a mortgage, a car payment, and Lily's future to think about. A lien on their home was a terrifying prospect that could ruin their credit and their financial stability for years. Just take it down, she pleaded. Please, it's not worth losing our home. That evening, as Arthur sat on his porch staring at the fence, now a symbol of his impending financial ruin, George Peterson walked over, a look of grave concern on his face. I heard their lawyer sent you a letter, he said softly. Arthur nodded, too dejected to speak. I need to tell you the rest of the story, George said, taking a seat in the adjacent chair. Back in 2011, Michael Albright was finishing the last phase of the development. His own house, the big one on the ridge at the end of the cul-de-sac, was the crown jewel. He designed it himself. Its main selling point was the unobstructed panoramic view of the valley. But to guarantee that view, he needed to make sure no one in this row of houses, our houses, could ever build a 2-story addition, or even plant a tall tree. Arthur's eyes widened. So, George continued, he had his draftsman create a new version of the plat map, just for the HOA's internal use. It had that view corridor easement drawn in. He got the board at the time, all his own appointees, to adopt it as the official map, the real map, the one he had to file with the county to get the permits. Doesn't have it. He protected his own investment by secretly taking land use rights away from a dozen of his customers. A silence settled between them. So Carol knows, Arthur stated, the realization hitting him like a physical blow. She knows the map is fake. She's protecting him, his legacy, their finances. She's terrified that if the truth comes out, it could open them up to a massive lawsuit from everyone who bought a house on this street. George sighed heavily. And there's more. Arthur, that's why I have to warn you. He gestured toward his own backyard, where a lovely stone patio with a built-in barbecue sat. I built that patio 10 years ago. It's fully compliant with the HOA's fake map. But it extends 2 feet into the actual rear setback line, defined on the real county map. Carol approved it herself back then. If you expose the real map to prove your fence is legal, you'll also be proving that my patio, my pride and joy for a decade, is an illegal structure. They'll make me tear it out. The weight of George's confession settled on Arthur. He was no longer just fighting for himself. Winning would mean harming his kind. Elderly neighbor. A man who had done nothing wrong but trust the same fraudulent system he was fighting. The path to victory was now paved with a terrible moral dilemma. His final piece of the puzzle came from a retired county clerk named Eleanor. A sharp, cynical woman with a deep distrust for bureaucracy, whom he met while struggling with the archive's microfiche machine. Taking pity on him, she used her old login credentials to access deeper, undigitized archives. There, She found it a set of unredacted draft minutes from a 2011 County Planning Commission meeting. In it, a note read, Developer M. Albright's proposal for a scenic easement on lots 118, 128 was reviewed and denied as it did not meet public utility requirements and constituted an unfair encumbrance on private property. He now had irrefutable proof, not just that the HOA's map was different, but that the developer had tried and failed to create the easement legally, and then had proceeded to enforce it illegally anyway. He had the whole story. Now, he just had to figure out how to tell it without destroying his neighbor. The Oak Creek Preserve annual meeting was held in the community clubhouse, a sterile, beige room packed with 50 folding chairs and the oppressive humidity of a July evening. The air was thick with the scent of stale coffee and suburban discontent. Arthur sat beside Sarah, his hands resting on a slim black binder. His heart wasn't pounding. It was a cold, heavy stone in his chest. He was an architect, a man who worked with blueprints and logic, not a public speaker, but Carol had left him no choice. Carol sat at the long table at the front of the room with the other 4 board members. She looked serene, confident, occasionally whispering to the HOA's attorney, a man with a perpetually smug expression. After a tedious hour of budget reports and landscaping committee updates, the board president, a stoic man named Frank, who was a known ally of Carol's, looked down at his agenda. The final item of new business is the hearing for the violation at 124 Chestnut Lane. Mr. Henderson, you have requested to address the board. As per our rules of order, you have 5 minutes. Your time starts now. A large digital timer appeared on the projector screen behind the board, the bright red numbers glaring 0500. Arthur took a deep breath, walked to the lectern, and opened his binder. He placed his first exhibit on the document projector. Good evening, he began, his voice steady and calm. My name is Arthur Henderson. The board is here tonight to rule on a violation notice regarding my fence, which the ACC claims encroaches on a view corridor easement. The timer clicked to 04:45. The board is citing CC&Rs, Section 8.4.2, as the basis for this violation. He projected the text of the rule for all to see. This rule states that no structure can be placed in an easement designated on the association's official plat map. He paused, letting the words sink in. He then replaced the page with his second exhibit. The timer showed 03:30. However, he continued, the CC&Rs also contain Section 12.1.5, which is the governing clause for all property boundaries. He projected the text of the second rule. This clause states that all boundaries are defined exclusively and finally by the official map filed with the Summit County Recorder of Deeds. The county map, not the association's map, is the ultimate legal authority. A low murmur rippled through the audience. Carol sat motionless, her expression unchanged. The timer hit 02:30. This is the map the association provided with my violation notice, Arthur said, projecting the HOA's map. He used a laser pointer to trace the easement cutting through his property. And this, he said, his voice ringing with clarity as he slid his next exhibit onto the projector, is the official, legally recorded plat map from the Summit County Recorder's Office, certified this morning. He had overlaid the 2 maps on a transparent sheet. The discrepancy was shocking, undeniable. The easement was present on the HOA's version, but completely absent from the county's legal document. A collective gasp went through the room. Homeowners leaned forward, whispering to their neighbors. The timer read 01:30. Carol's knuckles were white where she gripped her pen. The attorney was no longer whispering. He was staring, slack-jawed, at the screen. As you can see, the view corridor easement on my property does not legally exist. Arthur stated. It was added to the HOA's internal copy of the map, in direct contradiction to the legally filed documents. The timer hit, year 045. He put up his final exhibit, the redacted HOA minutes from August 2011, next to the unredacted note from the County Planning Commission meeting denying the easement's creation. These documents suggest that the developer was aware the easement was not legally permissible, but proceeded to create a fraudulent map to enforce it anyway. And the minutes of the meeting where this was likely discussed have been illegally redacted from the homeowners. The timer showed DUIGU 15. This was the moment. He could expose the entire fraud, name Michael Albright, and by extension, demand a reversion that would jeopardize George's patio. He paused and made eye contact with George, who was sitting in the third row, his face pale with anxiety. Arthur saw not just a neighbor, but a fellow homeowner who had been deceived. He took a breath and made his choice. "I am not here to punish my neighbors," he said, his voice firm with conviction. Many, like Mr. Peterson here, built structures in good faith based on the faulty documents this board provided them. They should not be penalized for the board's deception. He looked directly at the board, at Carol. Therefore, I am not asking for a strict reversion. I am proposing a motion from the floor first, that my violation be dismissed. Second, that the board be required to correct its official map to match the county record immediately. And third, that the board be directed to grant automatic variances for any existing structures, like my fence and my neighbor's patio, that were built in compliance with the fraudulent map. The timer flashed, Yoju Woju. The room was utterly silent. The silence lasted for 3 heartbeats, a stunned vacuum in the wake of Arthur's presentation. Then, the room erupted. It wasn't anger, but a cascade of anxious, urgent questions. A woman in the front row shot to her feet. "Wait a minute. My lot is on that street. Does this mean the association has been enforcing a non-existent rule on my property for 10 years? Another man stood up. "I wanted to plant a maple tree in my backyard 5 years ago, and Carol's committee denied it. Citing that same view corridor, was that denial illegitimate?" The questions became a torrent, directed not at Arthur, but at the suddenly besieged board. Frank, the president, banged his gavel weakly. But the procedural order had shattered. All eyes were on Carol. Her face, once a mask of serene control, was now pale and tight, her composure crumbling under the weight of a dozen accusing stares. The HOA's attorney was frantically whispering in her ear, no longer offering strategy, but performing damage control. He looked like a man trying to plug a dam with his finger. From the back of the room, a homeowner with a booming voice, a man Arthur recognized as a retired litigator, stood up. "I move to immediately freeze and void all fines and violations related to CC&R's Section 8.4.2 for all homeowners." Second came a chorus of voices. Frank, flustered, called for a vote. It was nearly unanimous. Before he could regain control, the litigator spoke again. "I further move that the association immediately fund a full, independent forensic audit of all plat maps and recorded easements against the official Summit County records, to be conducted by an outside firm with no connection to this board or its past legal counsel." Second. The motion passed with another overwhelming roar of aye. Finally, a quiet woman who had never before spoken at a meeting stood up, her voice shaking but clear. "I move for a formal censure of ACC Chairperson Carol Albright and any board members who were aware of and knowingly enforced rules based on this fraudulent document." The censure motion passed. The meeting descended into procedural chaos. The board's authority had evaporated in 5 minutes. dismantled by a quiet architect with a binder full of facts. Carol Albright sat frozen, a statue of disgraced power, as the community she had ruled with an iron fist voted, piece by piece, to dismantle her legacy. In the weeks that followed, the audit confirmed everything Arthur had uncovered. The fraudulent map was identified, and the law firm that had drafted it for Michael Albright a decade ago issued a carefully worded statement of apology, citing a profound clerical error. The board, facing a potential lawsuit from the entire neighborhood, sent a formal letter of apology to Arthur. The violation was expunged, the fines were voided, and his fence was retroactively approved. As a result of the censure and the overwhelming loss of confidence, Carol was removed from the ACC and quietly resigned from the board of directors. A new, transparent system of architectural review was put in place. Arthur's life returned to normal, but it was a new normal. Neighbors would nod to him with a newfound respect. George Peterson brought over a bottle of fine scotch, and the two men shared a drink on George's now legal patio, a silent acknowledgement of the choice Arthur had made at the lectern. He hadn't just won. He had acted with grace, transforming a personal victory into a communal correction. He had built a fence and, in the process, mended the community. The final surprise came a month later, in a phone call from Eleanor, the retired county clerk, who had taken a personal interest in his case. "Thought you'd find this interesting, Mr. Henderson," she said, her voice crackling with the satisfaction of a puzzle solved. "I did a little more digging into the property transfer records for the developer's old lot, the one on the ridge." And Arthur asked. Michael Albright sold that house in late 2012, about a year after he pushed through that fake map. She explained, and he sold it for a 30% premium over the assessed market value. "I found the old sales listing. It explicitly marketed the property's single greatest asset, a deeded and protected panoramic view, guaranteed in perpetuity by the HOA's strict covenants. That view, Mr. Henderson, was the one created by the non-existent easement on your property and your neighbors." The final piece clicked into place. This was never just about legacy. It was about money. It was textbook real estate fraud. Michael Albright hadn't just protected his view. He had illegally manufactured a high-value asset, sold it for a massive profit, and his wife had spent the next decade desperately trying to protect the secret. That evening, Arthur sat on his back porch, watching the sun set behind the distant hills. Lily was playing on her swing set, her laughter rising and falling in the twilight. The white fence stood clean and bright, a simple line drawn in the grass. It was a boundary he had fought for, not with anger or influence, but with diligence, facts, and a belief in the simple, foundational power of the truth. He had faced down a bully, not by stooping to her level, but by rising above it, armed with nothing more than the rules she claimed to revere. He raised his glass in a silent toast to the quiet, unassailable victory of a problem, correctly solved.